Welcome back to More Law on Fox 19, your legal questions live, with local broadcaster and award-winning reporter Deb Haas and Cincinnati personal injury attorney Don Moore, recognized by Ohio Super Lawyers. More answers, more help, more law on Fox 19.
Now we'll take you to More Law Connection, where Dan Moore is answering viewer emails. Good morning, Dan.
Thanks, Deb. Good morning to you. Today, our first question is from Margaret. She says, a friend of mine tripped on my porch steps and broke her leg. Does my homeowner's insurance have to pay for her medical bills? The answer is a qualified yes. Homeowners insurance oftentimes has a provision that provides that they will pay up to $5,000, sometimes $10,000 worth of a person's medical bills that gets injured on your property. And it's regardless of who's at fault. Now, once the bills reach $5,000 to $10,000, homeowners insurance is probably not going to be responsible for anything additional because this incident is not Margaret's fault. Most of the time when somebody trips downstairs or injures themselves on stairs, it's the injured person's fault. Assuming no exceptions apply here, then the homeowners will be limited to just paying that $5,000 to $10,000. Deb, back to you.
All right, Dan, thanks. We'll get back to our topic of the truth about trial lawyers. Our guest today, John Holshoe, thanks for being here.
Thank you for having me.
All right, let's go back to the callers now. Let's see, I think we have Pat in Manchester. Go ahead, Pat.
Hi, I have one question. I was in the hospital for almost 30 days, and they did brain surgery on me, and they couldn't get a hold of my sister to approve it, but she was out of the country. So they just went ahead and did it. And I can't get any answers. I just found out, it was done in February. I just found out last week that I have a metal plate in my head. And none of my doctors, I have 5 doctors I'm working with, none of them want to answer any questions or give me any information on it.
So then, just so I understand, Pat, your question is, how were they allowed to do that without somebody approving it?
Yes.
Okay, John, would you like to talk about that?
Sure. First of all, I'm not sure exactly who consented or for what reason this was done. In order to find out, the most important thing would be to obtain the medical records and see what the medical records indicate as to what was done and why it was done. Again, without having the records, I really am a little hesitant to give you any opinion. But
I do have brain cancer.
Okay. It may have been a life or death situation, and the physicians, in their judgment or determination, if they were unable to get a hold of the next family member, went ahead and proceeded in order to save your life. Again, I don't know without having your records and having them reviewed. So without that, it's really difficult to give you any firm thoughts or opinions. Again, I always tell people, if you have questions, go to your doctor and talk to your doctor and see what your doctor tells you. And it sounds like you may have done that and you're not getting the answers.
I'm not getting any answers. In fact, when I go in the office now, my oncologist actually turns his computer off and says it's not working.
Well, again, you may want to consult with an attorney, have that attorney obtain the records, and then maybe the attorney can give you some thoughts or opinions as to what happened and why it happened.
Okay. Thank you.
Thank you.
And Don, you wanted to add to that, I believe.
Yeah, one of the things that Pat may be talking about is a potential lack of informed consent case. And that basically, informed consent is they get permission, and they get permission based on them giving you information so you can make a reasonably good judgment about whether or not to have the procedure. Now, frankly, those are weak cases typically, because the test, at least in Ohio, is would a reasonable person under the same circumstances have given permission? You've got brain cancer. If it's something you're not capable of appreciating, basically the choices and so on, they felt like they really didn't have a choice. If a jury would later find that the reasonable person would have given them consent, you don't have a case. So because these guys are all nervous about talking to you, doesn't necessarily mean that there's something there. It may be worth checking out, but lack of informed consent basically is like a technical battery. They don't have permission, so they're not allowed to touch you, but the law in Ohio is if a reasonable person would have consented, there is no case.
What a hard situation to be faced with. Let us go next. Let's see, we have Barbara in Fairfield. Good morning, Barbara.
Hi, good morning. I have a question. I recently hired a roofing contractor who required half the amount of the deposit up front. And at the time, I needed to cancel the contract an emergency came up and funds became short 2 days after. But anyway, the contractor at the time of signing the contract did not give me a contract, and I was not even aware that I had 72 hours to cancel. So now he's threatening to take me to court and not refund any of my funds to me. What would a lawyer do in this situation?
John?
Well, once again, it's going to depend on what the contract says and the terms of the contract. If you signed a contract stating that you would agree to pay those amounts for those repairs and the roofing repairs or whatever, and it's a written contract and you signed it, then you're going to be bound by it, unless you could show fraud or deceit or some other way to avoid the contract. Again, without having the contract in front of me or knowing more about the details, it's hard to give a firm opinion, but I think from what you're describing, if you signed a written contract, you may well be bound by it.
Okay.
And you know, I agree with what John said, and frankly, in a case like that, a person may have a right to rescind, but they're just liable for the damages. So she may not owe for the whole contract, she may just owe for what the contractor actually lost if he hasn't done the work.
Correct.
So that's something that, as John said a minute ago, that she can find that out by giving more details to a lawyer.
Right. Best of luck to you on that, Barbara. And now we will go back to Dan Moore with another email question. Dan?
Thanks, Deb. This next question is very similar to what we just talked about. It's from John. He says, I hired someone to replace my roof, but they haven't finished and won't answer my calls. What is my recourse at this point? Now, again, breach of contract case. When you have a contract, that contractor is supposed to do what he has agreed to do in the contract. Now, if he doesn't, he's breached it. What the law does to fix that is it allows you to go and hire another contractor to come in and finish the work. Now, if that second contractor is charging more than the first contractor was going to charge, that first contractor is going to be responsible for the difference. Unfortunately, sometimes the only time to get that difference is to file a lawsuit against that first contractor. Now, if you have a question, go to the Fox 19 website, click on the More Law button, go to Send Us Your Questions form, fill out that form, and submit it. We will do our best to answer your questions. That is all I have for today. Deb, back to you.
Thank you, Dan. And we will be right back here with More Law, the truth about trial lawyers. Stay with us. We'll be right back. Indiana Bar Associations require we give the addresses of the attorneys on the show. So here we go. We have John Holshoe, Stanton and Hughes, 600 Vine Street, Cincinnati 45202. And of course, Don Moore with the Moore Law Firm, 1060 Nimitz View Drive, Cincinnati 232-2000. Of course, you can find all of this, fox19.com, and click on More Law. And of course, that's where you can watch all of our previous shows. Now, Don, as we talk about the truth about trial lawyers today, you think it's important to talk about the Seventh Amendment.
I do indeed. I love talking about the Seventh Amendment. The Seventh Amendment is the amendment both in Ohio and federal constitution that basically says that juries have the right to decide civil cases, and people who have been injured and injured have a right to have a trial and have them decide it. So there's 2 points I want to make sure everybody understands. That is that you not only have a right to have a jury decide your trial in a civil case, but they decide the amount, and the amount is not to be changed by anyone else thereafter. It says it won't be re-examined. That's the verbiage in the federal constitution. And the idea is to check the power of judges and other interests from basically making the playing field equal or level for the private individual. So if a person goes up against a huge company because they've been injured by negligence of that company, they should have equal footing. Now, so why am I so excited about that? Well, I'm real excited.
Yes, Don, why are you?
Yeah, that's right. Well, I'm glad you asked, Deb. I'm real excited about it because there has been a trend lately to say that there's something bad about juries. That is, that we can't trust the ordinary people to make decisions. So there's mandatory arbitration. There are legislative limits right now. If there's punitive damages, there's limits on that. There are limits on pain and suffering, like the legislature sitting up in our state in Columbus or in the Washington, D.C. Like they know more about what an individual case is about than 8 or 12 people sitting there listening to all the facts. That's hogwash. But it's been sold to all of us, and many people believe, oh, we should have a limit on what jury trials do. And frankly, I've been doing it for over 32 years. John Holshoe, who's our guest today, has been doing it for that long as well. We also have family members in it, and the fact of the matter is, it simply is a lie. Juries can be trusted. They get it right most of the time. And I sure trust juries more than I do an arbitrary limit set by legislators. So do I sound worked up?
Well, that's the term I was going to use. This is Don Moore at his most worked up, everybody. Let's calm down for a second and let's talk to Kristen in Mount Healthy. Go ahead, Kristen.
Yeah, my question is it a certain cap on all the personal injuries that the limit they're allowed to give, or is it just based per case?
And that's a little bit about what Don was just saying. Can you explain that to her?
Absolutely. The legislature has enacted a law that does limit non-economic damages. Economic damages are your lost wages and your medical bills. There are no limits in a personal injury or medical malpractice case on economic damages. The non-economic damages, which are basically, as we laymen know it, as pain and suffering, there is a limit on that in both personal injury and medical malpractice, and it varies. In medical malpractice, the limit has to do with the severity of the injury, the number of people that are injured, whether it's a husband and wife, and so on. So there's a whole statute that the legislature enacted back, I think it was 2004, that limits exactly how much can be awarded, both in an automobile accident as well as in a medical malpractice case. Two different statutes, but there is a limit on, again, non-economic damages.
Okay. And we are just about out of time. John, thanks for joining us today.
Deb, thank you.
Great to have you. And next week, Don?
Fighting the insurance company, something else we could really get worked up about.
I have no doubt.
In fact, we're going to have a fellow here next week who's spent a career working for insurance companies, and he's going to ask everybody's questions about their insurance, answer everybody's questions about their insurance claims.
Okay. All right. Great. Thank you. Thank you for joining us. We will be back here next Monday morning at 9:30 again, taking your calls about how to deal with your insurance company. Have a good week. We'll see you next week.